Thank you for joining us here on Just Conspiracy, where we just wish to conspire about bringing heaven down to earth. So, without further ado, let's get right into it. One of the last things I talked about was the ACLU moving against Johnny Depp, saying, hey, you want to pay us, you're gonna pay us for our cooperation, for our being an accessory before the fact, for our enticing Amber Heard to defame you. You gotta cough up that money. Well, there's been an order entered. Let's check it out. Supreme Court of the State of New York, New York County. Johnny Depp v. American Civil Liberties Union Foundation, Benjamin Wisner or something, Anthony somebody else. Order, decision plus order on motion. The following e-file document listed by NYSCEF document number were read on this motion for attorney fees. Upon the foregoing documents and for the reasons stated on the record during oral argument on July 1st, 2022, respondent's motion is granted in part solely to the extent of awarding respondents $38,000 in reasonable production fees and costs. Petitioner must make payment within 90 days from the date of today's order. And then it has the date and something that kind of looks like a signature, might look like a sign. So, I don't know how many people know about Donald Trump and Stormy Daniels. I had to really dig into it. But one thing that I knew, kind of from looking into it about a year and a half ago, is that Donald Trump was awarded $300,000 or close to against Stormy Daniels for Stormy Daniels bringing a frivolous lawsuit against him. Amazingly, she was awarded this from an anti-SLAPP statute. Federal judge in Ohio sides with Stormy Daniels in legal fight with Donald Trump over settlement. U.S. District Court Judge Michael Watson in Columbus ruled this week that Trump cannot touch the $450,000 settlement Daniels reached last year with Columbus over a botched arrest at a strip club. So, here's basically what happened. Stormy Daniels came out with all of this stuff that she wasn't supposed to talk about when the greatest president ever, period, was in office. Apparently, the greatest president ever, period, paid her $130,000 as hush money. No, she's probably just a really expensive prostitute that only people like Donald Trump can afford. He paid her $130,000 as, hey, shh, don't tell anybody we slept together, especially not the missus. It could cause some problems in my home life, if you know what I mean. And she took the money, and then she told everybody what they did. I have a strictly kiss and don't tell policy. Apparently, you can't trust porn stars to have a kiss and don't tell policy. Yeah, they typically record it and show it to the entire internet. Let's see what happened. Brewster said Trump's attorney sought to collect, even though a judgment on the defamation case was never reduced the attorney's fees order to a judgment. See, Trump got an order from a court for attorney fees But Trump couldn't collect on that order because it was not a court judgment. So, Johnny Depp, because we got so much in common, like the initials to your name is JCD, and the initials to my name are JDC, I figured that I would try to extend this advice to you before you actually pull out your checkbook and write the ACLU that extortion check that everybody knows you shouldn't pay. Everybody knows you shouldn't pay that. Because right here it says the order wasn't a judgment. You see, an order is one thing, a judgment's another thing. And if we go back to that order, yeah, it says decision plus order on motion. It doesn't say judgment anywhere there. It doesn't say judgment, but I'm not an attorney. This isn't legal advice. You probably want to go talk to your little hot thing, Camille. Oh yeah, probably. Now, I did a lot of searching, like a lot of searching for the order where Trump was denied his order for attorney fees. And I couldn't find it anywhere on Google. Like, even taking word for word what the order said and putting it into Google, I couldn't find it anywhere. Because Google just doesn't care about freedoms and public transparency and having an educated populace in America, but we'll talk about that later. Anyways, I did find it for you. And I'm going to go over it in a different video, probably not on this platform because it is awesome. It's only 8 pages. But I'm just going to go over a couple key points right here. You ready? Let's check this out. Okay, here we go. United States District Court, Southern District of Ohio, Eastern Division. You can see it's filed June 2nd, 2020. Here's my favorite part right here. Finally, plaintiff's current attorneys in this lawsuit seek to collect their attorney's fees before either Avenatti or Trump can collect their purported shares of the settlement proceeds. So let me explain what's going on here real quick. Stormy Daniels is suing the state of Ohio, and I believe the city of Cincinnati, but I'm not 100% sure on that. They wrongfully arrested her without probable cause. She contends and argues those cops were Trump supporters because they know who the biggest, greatest president in the history of mankind is. And so they arrested her without probable cause because she kissed and told, I think. And so her civil rights were violated. She sued them. They settled out of court. They've already settled $450,000. You have her old attorney seeking legal fees, seeking his attorney fees. You have Trump's attorneys seeking their attorney fees. And you have her attorney representing her in this case right here saying, hey, I should get paid first. Trump is seeking about $300,000 in attorney fees. So I don't know what the other attorneys cost, but my guess is that that entire settlement is gone. And the individual who was actually harmed, wronged, injured, the little girl who doesn't know how to keep her mouth shut, kind of like another little girl I know who drops turds in the bed, she ain't getting nothing. And she's the one who had to spend the night in jail. I mean, I don't know she's not getting anything, but $300,000 already going to Trump's attorneys. Yeah, I think most of it's gone. I mean, just in that one little hit. And this just goes to show that courts aren't real good at paying anybody except attorneys, right? And if you have to pay an attorney for a right, it ain't a right. It is not a right. So let's continue further with this. Plaintiff filed a motion to vacate that registered judgment, arguing that the award was contained in the California District Court's civil minute entry, which did not constitute a valid judgment. You just had a minute order, and you didn't have a judgment, and they can't execute it because it's an order and not a judgment, because order and judgment mean two different things. And that doesn't really matter because they don't have to have a judgment. They don't have to sign a piece of paper. Believe me, I've gone to jail with no sentencing order found. I have had fines imposed on me and punishments with no court process anywhere to be found to say that this is okay and it's happening. And you want to know why? Because I'm trying to teach you that it's all an illusion, that it doesn't matter. So they're like, you want to see how much of an illusion it is? We'll beat you up without any of the documents anybody has to have to actually go through a lawful process, and nobody in society is going to care because nobody understands what their rights are. Ha ha. Good luck trying to teach them. That's how silly it is. That is exactly how silly it is. At the end of this, having concluded that neither Avenatti nor Trump currently have an enforceable interest in the settlement funds, and that a stay to determine if they will in the future is not warranted, the court hereby directs the clerk of court to release the funds deposited pursuant to this court's order to the plaintiff and her attorneys. The clerk is further directed to terminate all pending motions and close this case. It is so ordered. You see, the judicial officer can make that order because here's what the judicial officer is doing. The judicial officer, Michael Watson, is ordering the clerk, who's under his authority, power, and control in his jurisdiction, to release the money that was already taken by the clerk for the settlement to the plaintiff and her attorneys. So basically to the people that the money was retrieved for. And then the judicial officer orders the clerk, which he can order the clerk because he has power, authority, and jurisdiction over them, to close the case. The judicial officer can order the clerk to do those things. And I bet that's a minute order too. I bet it's a minute order. It's not a judgment. Didn't say judgment up at the top. Kind of like Johnny's order. It doesn't say judgment. And then it says he must pay in 90 days. You're telling me I ain't got the right to appeal? I can't appeal? I can't appeal an order? I lost that right somehow, somewhere, some way. So a lot of people have been talking about this anti-SLAPP suit. Like, it's so smart that Johnny's attorneys, brought this case in California, because otherwise they would have been hit with an anti-SLAPP motion. Let's see what that is.
Posters. Emily, maybe you can explain that legal theory about there's more likely to succeed in a state like Virginia, say, versus California. I think people might be interested in that.
When we get into defamation, there's always a consideration of silencing somebody's speech, and we hold free speech kind of above all. Defamation's not protected speech, but in California, there's a very strong anti-SLAPP statute that can end litigation before it even begins. In Virginia, that statute is used as a defense, and it doesn't stop litigation before you get to discovery. I think this was a very strong strategic choice.
Explain what the SLAPP statute is.
I will. So it's the anti-SLAPPs are anti-strategic litigation against public participation. The thought that you could file a lawsuit to silence someone from releasing a book or releasing an article, to silence them before they even speak by using the courts. So in California, they look at those types of lawsuits very closely, and if you win on your SLAPP suit or your anti-SLAPP motion, then the case is dead in the water. It stops. You win attorney's fees. There's no discovery, so that somebody bringing a defamation suit has to have a lot of proof before they even get into court. In Virginia, they go through that long discovery process where you're getting text messages and body cam footage, and that is part of why I believe they chose Virginia, so that they could get through that discovery process to trial. In California, this case might have gotten kicked out before it started.
Wow, we learned about a whole different kind of slapping on this show tonight. All right, so
a whole different kind of slapping.
Around the horn.
Well, what's that about? You're telling me that if I have a reason, if I have a cause for action to go and sue somebody, I have to prove that I'm going to win when I file the lawsuit? When I file a suit for defamation? And the attorney's just like, yeah, the legislature can do that. See, it's okay for the law to be different in California than Virginia, because the legislatures dictate moral values. You know, like when slavery was legal, or killing Jews, or segregation. Because historically, society and the legislative branch of government has been so good at recognizing your rights. They've never abused that power at all, not for their own gain. They never wrote a document to say, hey, we cannot abuse this power beyond this point. Or maybe they did. So this comes from the Constitution of Virginia, not the Constitution of the United States, the Constitution of Virginia. Article 1, Bill of Rights, Section 11, jury trial in civil cases, that in controversies respecting property and in suits between man and man, trial by jury is preferable to any other and ought to be held sacred. See, it ought to be held sacred. That doesn't mean they have to hold it sacred. It doesn't mean it's inviolate. I think that's what the South Carolina Constitution says. So the wording here protecting that right is not very strong. But still, you think it's okay that all of these bad things happen to Johnny, and then he goes into court, and without a jury, without a real court of law, the administrative court, through a motion, can just say, yeah, we're not going to hear this. And not only are we not going to hear it, but we're going to make you pay her. Like, this could have happened. This seriously could have happened. If they were in California, they could have brought in the UK judgment and said, this is absurd on its face. We already have this judgment. He doesn't have enough proof. Make him pay for attorney fees. And then not only would he be paying for the ACLU's attorney fees, he'd be paying for little poo-poo heads' attorney's fees too. This is the world we're going to. This is the world we are going to be living in very, very shortly. Very soon. Very soon. And what kind of world is it? See, before we really talk about that, I'd like to kind of bring up another attorney's point of view on anti-SLAPP. and why anti-SLAPP exists. Let's check this out.
A Woodbridge Windows company was ordered to pay more than $100,000 to a negative reviewer because the judge said the company was trying to, quote, bully them. Here with a closer look at this case is Tanya Walker from Walker Law. Good morning. Nice to talk to you again. Nice to see you.
Good morning. Thank you for having me. It's great to see you.
This is such an interesting case, right? Ultimately, this company lost due to what they called an anti-SLAPP motion. So what is that? Walk us through that.
Okay, well, anti-SLAPP legislation was actually introduced in 2015, and it stands for Strategic Lawsuits Against Public Participation. And what this means is that someone cannot essentially slap you with a defamation lawsuit in a situation where you post an online review about your experience with a business. The judicial system wants to protect your right to freedom of expression without being afraid of being sued. So if someone sues you for a review that you posted online, the legislation allows you to make a request to a judge in a motion, that's what it's called, to have that lawsuit essentially dismissed. And when you make this request, the other side must show evidence such as you will not win the lawsuit in order to actually win that motion. So if this lawsuit is dismissed, the legislation provides that the judge may order that 100% of your legal fees be repaid to you, where normally in civil litigation, a judge is open to order that between 60 to 80% of your legal fees be paid back to you.
Now, I don't know if you know like the absolute specifics of this case, but it got me thinking. I was like, what did they say in the review that had this company so like angry and annoyed and going after them? Do you know that?
Yes, I read.
Okay, so here's kind of the idea of the anti-SLAPP lawsuit, and that is you have freedom of speech. Companies, corporations have a whole lot of money and most people don't. Okay, so sometimes they use this money to silence people who give them bad reviews, or they don't like what they're saying because somebody didn't like their product. So they bring a lawsuit against them just to get them to shut up, sit down, be quiet, and fall in line. And just take it. Because we're supposed to have rights. Now, most people would be really, really hurt by this if they didn't have this anti-SLAPP legislation, statute. And they would go, seek an attorney. They'd have to pay the attorney, and then they would have to pay the attorney at least 20% or 40%. Whereas if you win on this motion, you got to pay the whole 100. And when it's being used for this purpose, okay, you know what? I think that should apply. When you have anti-SLAPP between corporations, or when a corporation is suing an individual and you have anti-SLAPP, okay. I think that works out pretty well. When you start moving that into the world of man, when a woman or a man has a legitimate cause of action, and you stop that cause of action because of this legislation, and you impede the rights and justice of mankind for your own political gain. I don't know if that's what happened in the Trump and Stormy Daniels suit. I mean, personally, I don't think that happened because she got paid off a bunch of hush-hush money and then went around singing and sued Trump for something. I don't even remember. But you can't run around and sue somebody because you're talking about them paying you off and you agreed to it. I don't think that's going anywhere. And on its face, okay, but what about Amber Heard and Johnny Depp? Because Amber Heard had a decent argument. They're still pushing the argument. England. And now that we know that attorneys basically think, okay, hey, wait, rights can be violated by the legislature, that's okay, because that's how law works. That's our due process. Surely the appellate court wouldn't get it wrong, right? Like, surely there's going to be some law there. Let's check it out.
But in the defamation context, truth is an absolute defense. Another.
So just so we're clear, now, no matter if you're taking any bar exam, anything like that, if they give you a statement that's true, right? If you're taking a bar exam and a question comes up and they say the statement is true, you've lost your that's a losing defamation case. So that's where we're at right now. We have a statement that's technically true, that their argument is technically true, and as a defense, it's an absolute defense because you can't recover for true statements, and there's a First Amendment issue for that too. So let's go now to see what Amber Heard and her team are saying about whether the statements are true or not. That's found on page 22 of this motion. So let me pull this back up, put it on the screen so you guys can see it. And we'll go to page 22 so we can see how they're trying to say that the statements are essentially true. And Amber Heard should be afforded an absolute defense for those statements. Here we go, statements 22. The first, and as you can see, the First Amendment. It's up on the screen. Nope, I got to put it on the screen for add to screen. Here we go. Boom. The First Amendment bars recovery for defamation by implication when the statements at least are true on their face and involve a public figure or matters of public concern. So that's where they're going. And I think this is probably their best argument. Now, I don't know if it's going to be successful or not, but I think this is their best argument because if you can prove the statements are true, it is an absolute defense. Let me get some of these super chats out of the way real quick before we get into this. Very good point. Please tell me AH doesn't have a chance. I can't tell you she doesn't have a chance. I'm just saying her chances are are smaller than her chances are better than none, right? This is not like she's her chances are better than none. And for me to say otherwise would not be honest with the facts and what we're looking at, right? So I'm not saying she has a 70% chance, 80% chance, but it's not like she doesn't have a shot. And I think this truth defense has to kind of be flushed out for us to really understand whether she has a good chance or not. But at this point in time, she has a shot. How good that shot is, we're gonna have to determine. I don't think she even really has a shot with this judge, because I think this judge has made it very clear. This is, I'm done with this. But I think with an appeals court, this is something that you're gonna have to look into. So let's look at.
Does Amber Heard have a shot? Well, truth is absolutely a defense. 100%. And it should be. I agree with that. Unless the truth that you're talking about was based and predicated on a lie. Because basically what Nate the lawyer is saying is he's saying, if you watch the whole video, Amber Heard was found in defamation, being liable for defamation, for a statement which said, 2 years ago, I was thrust into the public spotlight as a representative of domestic abuse survivors, or something to that effect. And that is true. That is a true statement. In 2016, she got thrust into the public spotlight over the domestic violence issue. She became an ACLU ambassador over the exact same thing, and she is still an ACLU ambassador, if you believe it or not. So here's the defense, and what this attorney's saying, because he doesn't know, like he doesn't think that it will go through, but maybe it could. And so basically what he's saying is that there's no definitive law here. There's no right and wrong. Even though the judge in Virginia got all of the facts and couldn't make a judgment, told the jury to go get the judgment and come back with it. Even though she couldn't do anything with it, and most likely she won't. 3 people on the appellate court deciding in unison can say, oh no, the jury got it wrong. The facts are wrong. The judgment's wrong. And we got to set everything aside. Well, why even have a jury trial? Why don't we just skip the wasting of everybody's time and go straight to the government taking everything away from us? Why even go through that process of having a jury, of not allowing the judge to make a judgment, because only the jury can, because they're the ones with that power, if 3 judges can take it away? 1 judge isn't powerful enough, but 3? Now we got 3... and we think the jury's stupid. We don't agree with their argument for political reasons. This should have been anti-SLAPP. And if that happens, Nate would be telling their client, well, I thought you had a really good case. But the judge said, the 3 judges said, I don't know what Camille would be telling Johnny. He'd be heartbroken. He would be heartbroken. And so we can't trust the legislative branch to uphold our rights because they keep taking them. We can't trust the judiciary to uphold our rights because they give away what's rightfully ours. There's this other branch of government, I think. Maybe we can trust them. Oh, you know what? It's not a branch of government. It's not a branch of government at all. It is the media. Yeah, the media. Well, we can trust what they have to say, can't we? Like, they wouldn't ever make things up. Would they? Let's check it out.
Yeah, and you know what? Even if you had realized there was this need and then jumped on it once it already... that's fine. There's nothing wrong with that. And what really bothered me and why this piece particularly stuck in my craw, so to speak, is because she makes this whole point about how YouTubers don't, they don't have to abide by journalistic ethics, and they're just, the whole point is like, oh, they're just chasing the money. As if the mainstream press doesn't have their own incentives and money-making ventures backing them. And also, ironically, in this piece that's in part about how YouTubers don't have journalistic ethics, Taylor Lorenz herself violates journalistic ethics by lying about whether or not she reached out to for comment to you and another content creator. So talk us through that part of the story from your perspective.
So what happened was I saw that she had published the article, and to be honest, I wasn't following her. I was vaguely familiar with her before this, but not really, only just surrounding some sort of vague, I guess, controversies, you could say. Mm-hmm. But other than that, I really didn't know one thing about her beyond that. Didn't really have too many opinions about her, to be honest. But somebody had tagged me on Twitter and said, hey, you've got an article that's about you, and it's not great, and this had already happened a couple of times. People have been talking about LawTube, so to speak, and other content creators in the context of this trial. So I was like, okay, more shade, whatever. But I took a look at it, and I saw that she said that she had reached out for comment, and I was like, I mean, I've gotten a lot of emails in the last couple of months. Like, things have been pretty crazy. But let me double check my email just to see if she, like other journalists, reached out to me. I looked for her first name, her last name, Washington Post. I saw nothing. There was nothing in my email indicating any kind of professional that was reaching out to me for comment. So I tweeted about it and I said, I don't think this is accurate, but, okay. And then I saw that the other content creator that was in the same paragraph as me, that umbrella guy, he and I follow each other also because he's been one of the most active and most prominent in the Justice for Johnny Depp community for years. And so he said the same thing. So I was like, okay, so it's not just me. I'm not missing something. So then I get a direct message from her on Twitter saying, hey, I'm so sorry. Here's my phone number. You can reach out to me. And I was like, okay, well, you referenced the information that you got about me from this Business Insider article. That article also mentioned that I'm living overseas. So it feels very disingenuous for you to give me your phone number for me to reach out to you if you know that I'm overseas, because obviously you have definitely read that article if you're referencing it.
Right.
So then I guess about 10 minutes later, she also DM'd my Instagram account as well. So several iterations of corrections later, then I see, well, I guess before that, one of the first corrections was, I guess, the stealth edit of removing that parenthetical saying that she had reached out to us. And then there was the correction, of course, that said, you know, we removed that parenthetical, there was an error, blah, blah, blah. And then there was another correction after that saying, well, we didn't reach out to that umbrella guy, but we did reach out to Alita Majeka for, you know, through Instagram. When that was actually the last place where she tried to reach out to me after she had reached out on Twitter privately after I had already called her out.
So we have your tweet, guys. Go ahead and put this up on the screen that has this final editor's note. And you say, what? At Washington Post, I will say this again. I was not reached out to by Taylor Runs for comment until after my tweet below. She reached out to me by Instagram DM after she did on Twitter. Both DMs were sent to me after I called her out here. Please stop lying and take the L. And I'll just read the editor's note here so people can see how extensive this is. And I want to make sure that I have the timeline right here too, Alita. So first, they just, once you guys call them out, they just sort of stealth delete we reached out to them for comment, which violates their own standards. They realize they violated their own standards and this is becoming a thing. Then they issue this correction, which then they make into an editor's note, which still is not correct. What it says is the first published version of the story stated incorrectly that internet influencers Alita Majeka and that umbrella guy had been contacted for comment before publication. In fact, only Majeka was asked via Instagram. And you say that's not true. After the story was published, the Post continued to seek comment from Majeka via social media and queried that umbrella guy for the first time. During that process, the Post removed the incorrect statement but didn't note its removal. That's a violation of our corrections policy. So this turned out to a complete mess. You know, I mean, listen, why is it worth like sort of going into the details of the, you know, the life of the story and the various corrections that were issued? What do you think is the broader point here, Alita?
Well, I mean, as you mentioned before, it is ironic that this whole point of this article was to say how mainstream media is no longer being turned to by the people because, you know, you have these influencers on TikTok and on YouTube who are suddenly pivoting their content to make a buck. They're clout chasing. They're just covering this because they want to increase their followers, increase their subscribers, that kind of stuff. And the subtext seems to be that this is dangerous because misinformation is a big deal, and who's there to fact check these dangerous influencers? When in reality, I'm just asking for fair reporting on this thing. And the truth of the matter is that when it comes to my followers, when it comes to me making any kind of a factual assertion to my followers and my subscribers, I have a community that is actually very well versed in the underlying facts. So if I get something wrong, they call me out on it.
If I get something wrong, I hope y'all will call me out on it. So we have a legislature that's fine with taking away our rights. We have a judiciary that's fine with going along with taking away our rights. And then we have a media that is completely unaccountable and just makes up whatever they want to make up, lies, and then accuses other people of having non-media standard morals. I mean, isn't that what we're kind of seeking and going after? As somebody who's going to say the truth, I mean, I don't know because I'm not a law YouTuber, but most of those people, like Legal Bites, Emily D. Baker, Nate the Lawyer, Rakita Law, and all the other people who do that stuff, from my understanding, they do it because they wish to explain to people what's going on when court is in the news and there's a bunch of legal stuff going on, because most people don't necessarily really understand. That's my understanding. And I think they all do a good job. I think they all do a really decent job. It's not that I dislike them. I actually enjoy watching their videos. It's just where I see the problem, and the problem is that people in society have been taught you can't find law on your heart, you got to go to a specialist, and all these people who specialize in being an attorney and statutes and codes and codification, they don't understand that law is written on your heart. And they truly believe that the legislature can just take away your right to a trial by jury, and that a judiciary and a court can decide that those facts aren't real facts and that judgment isn't a real judgment. That's how stupid they think everybody is. Just look at the 7th Amendment of the United States. In controversies at common law, a trial by jury shall be preserved, and any fact tried by a jury should not be challenged. It cannot be changed in any court of the United States, not even the Supreme Court. What happened to that? And attorneys, I don't know what Emily's view was on the anti-SLAPP suit. I mean, it's kind of apparent that she thinks it's legitimate. I don't know if she thinks it should actually exist or not. But attorneys all of the time, very often, they disagree with the state laws. They disagree with the state statutes. They say, well, I don't agree with that, but that's just the way it is. And they still go along with it. They would still tell you that you have to pay if they were your attorney. Let's look at another attorney. This is Steve Leto. This is another attorney that I watch on YouTube. And I like him. We have some disagreements, but I generally like him. But let's see what he has to say about a statute he doesn't agree with. He actually names this video, "I apologize for the bad law Michigan just passed," as literally the name of the video. You think he agrees with the legislature? You think he thinks it's a violation? He's very big on this topic. Let's give it up to Steve Leto and civil asset forfeiture.
Safeguards. A 2016 investigation by USA Today found that between 2006 and 2015, DEA agents conducted over 430 cash seizures at the Detroit Metro Airport. All told, the DEA confiscated over $7.5 million in cash from just that one airport. That's the airport I fly into and out of most often. I don't travel through there with much cash very often, but I do go through there and I encounter those screeners. And I've got some crazy interactions I can talk about in a second. To fight back against unjust seizures, the Institute for Justice is currently litigating a nationwide class action lawsuit against the DEA and the TSA for violating the Fourth Amendment rights of thousands of air travelers each year. Their lawsuits already resulted in the DEA returning more than $82,000 to Terry Rollins, a retired railroad engineer who had his life savings confiscated, and the return of over $43,000 to Stacey Jones, who had her cash seized while flying home to Tampa. Neither of them were ever charged with a crime. Traveling with cash is not a crime. People regularly fly with large amounts of cash for a wide variety of completely legitimate reasons related to their business or personal finances. So there you go. But for some odd reason, the legislature in Michigan got together and all in consensus on passing this exception to the previous rules, and the governor signed it. And so, believe it or not, this is not even a political issue. People say, Steve, you shouldn't talk about politics. This is people on both sides of the aisle. Both sides. Everyone agrees we should crack down on cash at airports. Why not crack down on cash in I-94, which is the road that goes across the bottom of the state? Because people traveling, say, from New York to Chicago, or vice versa, will be traveling that road. Are there really that many people flying into and out of Detroit Metro Airport? who are bringing cash with them because they're committing a crime? Really? And I don't know what prompts someone to sit down and go, you know what we should do? We should crack down on airports. Again, I understand that people might commit crimes, and cash often is used in a crime. But that's why you have criminal asset forfeiture. So you catch somebody involved in a transaction that is criminal in nature. You arrest them. You seize the cash as part of the arrest. And after they're convicted, you bring in action to make them forfeit the money. Most people go, that makes complete sense. Why don't they do that? Well, they'd make less money. They make more money by just seizing cash from everybody. And they just assume you're a criminal if you've got cash. What kind of person has cash? Obviously criminals. So, I don't know what to tell you. I apologize. I'm sorry. If you're traveling in the future,
I don't know what to tell you. That's the law. The government can rob you with guns because the legislature says it's okay and the judiciary upholds it. I don't know what to tell you. You don't have to be a criminal. You don't have to be doing any crimes. And in fact, they say that they're taking this money to stop crimes on the street, but they don't charge people with crimes when they take this money from them, because if they charged them with crimes and they thought they could get a conviction, it would be criminal asset forfeiture. Who would have thought? Who would have thought? So let's look at civil asset forfeiture in Virginia. Just in Virginia. I'm glad he brought this topic up. Thank you, Steve. Virginia Department of Criminal Justice Services Forfeited Asset Sharing Program. In November 1990, the citizens of Virginia voted to adopt laws allowing local law enforcement agencies to benefit from the seizure of monies, property, and goods connected with the illegal distribution of narcotics. These laws made it possible for law enforcement agencies to receive the proceeds from the sale of items obtained in substantial connection with drug trafficking, and to have forfeited to them for agency usage certain seized items that could be used to promote law enforcement. Prior to the enactment of these new laws, all monies seized and received from the sale of forfeited items were handed over the State Literary Fund. Now law enforcement agencies can use these funds to their advantage. You mean before the civil asset forfeiture thing, when y'all were doing that criminal asset forfeiture thing, y'all were going after criminals and y'all were charging them for crimes and you were getting convictions, you were handing that money over to help illiterate people read? And you took the money from the illiterate people who couldn't read so that you could give it to law enforcement to rob more people? And here's the thing, is it starts off with the citizens voted for this. We got enough propaganda, we pumped their head full of enough stuff, we made them scared enough of all this gang violence going on that they said, yeah, take the money, don't get people reading, give it to law enforcement. Maybe we should give it to law enforcement to learn how to read. Maybe. I'm just teasing. There are a fair amount of smart cops. But when you're a police officer, it's like all of us, ignorance of the law is no excuse. But if you're a police officer It's okay for you to be ignorant of the law. There's no punishment when you're ignorant of the law because we're supposed to pay you to enforce it, right? Not exactly. That's why they call them police. They're policy officers. They're not law enforcement officers. And again, kind of like judgment and order, this is why people should really know how to read. Not just law enforcement, but everybody. You too. Okay, Institute for Justice. Steve Leto was talking about this group. Policing for Profit, Virginia. Virginia earns a D- for its civil forfeiture laws. Why? Low bar to forfeit and no conviction required. 100% of forfeiture proceeds go to law enforcement. There's kind of quite a conflict of interest in that, huh? We're going to go down here where it says Virginia ranks 30th for federal forfeiture with nearly 111 million in Department of Justice equitable sharing proceeds from the year 2000 to 2013. In 14 years, they got $111 million from robbing people. They rank 30th in the country. That's below good. That's below good. So, what happened after this? Because this only goes up to 2013. American Legislative Exchange Council talking about how good of a job the Virginia legislature is doing. Let's see what they got to say. I'm really interested. So this comes out on March 11, 2016. On March 10, 2016, the Virginia House of Delegates unanimously voted to reform a certain aspect of their civil asset forfeiture system by passing SB 457. The bill changes the burden of proof outlined by the Virginia State Crime Commission from preponderance of the evidence to clear and convincing evidence. This bill would make it more difficult for the government to obtain a judgment of forfeiture because it requires a higher burden of proof for the Commonwealth in the forfeiture proceeding against the property owner. The bill also allows an owner whose property was seized to request a trial by jury during the forfeiture proceeding should the Commonwealth seek to have the property forfeited. Let's talk about a couple of problems here. Okay? They're still not charging you with the crime, and they're saying instead of a preponderance of evidence, instead of us just making up the facts that we want to have to pay ourselves money, we're going to have a level of clear and convincing evidence. They have to give us clear and convincing evidence. Well, you're still just letting one individual make that decision. And they talk about having a trial by jury, but the individual whose property's getting taken, they have to pay to initiate that. They have to pay to proceed with that. Which means if you have to pay an attorney to exercise your rights, you don't really have any rights. Because attorneys are really, really expensive. Most people in America, I believe it's like 60%, could not afford a $400 out-of-pocket expense in a month. It's not budgeted. That would get you about 1 hour with an attorney. You couldn't even request a jury trial for that. Why shouldn't the state have to convince a jury that you don't deserve to have the money and that they do? I mean, just look at Johnny Depp. He had to sue, file a lawsuit, and go after Amber Heard to try and get money. He had to convince a jury. He had to do all the rigmarole. He couldn't just go and take Amber Heard's money, even though she did really, really wrong to him, and say, well, now you have the right to take me to a jury to see if the jury thinks you should get your money back. That's not how law works. And the reason they can get away with this is because nobody knows how to read, no one's real educated, and everybody seems to know that the government's screwing them, but they all seem to trust the government for some reason. I don't know why, because this is America, and in America, we don't trust government. Let's keep reading. The modifications to the state code signal a shift in Virginia politicians' attitude towards civil asset forfeiture. The Institute for Justice and Freedom Works both gave the Old Dominion's asset forfeiture laws a D- grade for performance. Although the Virginia Senate rejected a proposed amendment requiring a criminal conviction for the state to secure a judgment of forfeiture, SB 457 is nevertheless sure to improve that D- grade. This is a great sign. We're making real progress because the legislature has now written legislation to correct the legislation they used to rob us. And up until 2013, they robbed about $111 million from people. They didn't have to take them to court. They didn't have to convict them. They just robbed them. Surely that's going to change because now we have legislation to protect us from the legislation that harmed us. And we didn't just get rid of the legislation for some reason. I'm sure this is going to work out spectacular. Let's check it out. Institute for Justice again, policing for profit. Virginia earns a D- for its civil forfeiture laws. Wait, this has to be an old one. Wait, it has a better standard of proof, higher bar to forfeit in limited cases, weak conviction provisions fall short of criminal forfeiture. It applies only if an owner contests forfeiture, putting the burden on owners to engage in a costly legal battle and making it easy for the government to forfeit without conviction. And the financial incentive? Law enforcement still gets 100%. Instead of it going to people who can't read to try and educate our society and make them smarter. But if we educated our society and made them smarter, they probably wouldn't fall for this crap. So it's kind of a bad business move. Now surely, because here we go, state and federal forfeiture revenues from the year 2000 to 2019. So we know from 2000 to 2013, there's $111 million. And then in 2016, they wrote the statute to protect us from the statute that they had already written that was causing a lot of harm and problems in society, which is why they obviously had to write a new statute to protect us from the old statute, which just lets the state rob people for money without even charging them for a crime. Just because you had too much money in your pocket. See, you don't have the right to have too much money in your pocket. So surely we're gonna have like 150 million because they're that good at protecting the people. Between 2000 and 2019, Virginia law enforcement agencies forfeited more than 39 million under state law and generated an additional 296 million from federal equitable sharing for a total of at least $335 million in forfeiture revenue. So let's subtract 111 million from the 296 million that they're claiming in this article. That is 185 million that they stole in 6 years instead of 14. And 3 of those 6 years, they had a law in place to protect you from the bad laws. They had a statute in place to protect you from the bad statutes. This seems like a great idea. Let's all go get an attorney. If we can afford it. Because America and apple pie and ice creams, and we have rights. And we have rights. And this wouldn't be such an awful thing. Except Amber Heard is still an ACLU ambassador for women's rights. She is still an ACLU ambassador. The Civil Liberties Union that is charged with protecting American civil liberties, who's participating, in my opinion, in violating the law and conspiring to defame Johnny Depp, who had an order signed by a judge for Johnny Depp to pay them for conspiring against him, in my opinion, they won't get rid of Amber Heard. And why won't they get rid of Amber Heard? Because they don't have to. Nobody's going to make it so uncomfortable for them. Nobody's coming by to rob them for all of their wrongdoings. Just you. Just the public. Just good, decent people. And Taylor Lorenz, who talked about that umbrella guy, which I really, really enjoy him, and Legal Bites, let's see what happened to her. Washington Post, newsroom drama may have cost this features editor a promotion. I was looking up for whether Taylor Lorenz, because everybody heard the story, how she got demoted, how she got put back into the technology sector or whatever. So I look up, I'm like, hey, maybe she got demoted. Let's see if they cut her money. They cut her paycheck. I couldn't find anything like that. But in this report, it talks about, and if you know the story, then you'll know about it. It talks about the editor that she blamed the whole situation on because the editor didn't, clean up after her like a little child. Didn't make sure that she did everything that her job entitles her to do, declares that she does. She spoke out against him, and this article is all about how she cost him a promotion. And then this is my favorite part right here, because it kind of really proves my point, considering I couldn't find an actual pay cut. Where it's talking about her, from her own Twitter account, the reporter who used to be on the Times technology beat, denied an accusation on social media that she was demoted. I have absolutely not been demoted, not even remotely. My job has not changed at all. I joined WOPO as a technology columnist, writing tech features, and I still have that exact same position. Cameron has always edited my stories. He edits all the big stories on the site. He's always edited your stories. Really? Except for the stories that you post where you blame your editor for not editing your stories. Cameron edits all the other stories, huh? This is ridiculous and it's absurd. And in a lot of ways, it's really, really insulting. It's really, really insulting. people who do wrong, people who hurt other people in our society, they don't get held accountable. In fact, people who hurt other people in our society, they get to charge money for hurting the other people that they hurt, because we live in such a just society. That's why cops get paid to rob people in civil asset forfeitures. That's why the ACLU is going to get paid by Johnny Depp. That's why all the lawyers get paid, and none of the money's going to trickle down to the individual who actually suffered harm, injury, and/or loss. And people are just letting this happen. They're just allowing it to happen. I don't know what to do. The only thing I can say is, I got beer, come adopt me. These people are crazy. They are crazy. Anyways, all of the people from LawTube, all of the attorneys, I don't think they're bad people. In fact, I think the attorneys from LawTube really are trying to change things, really are trying to educate the people. I don't think any of the attorneys from LawTube would have taken money out of the literary fund and given it to police officers. If we keep going like this, what rights are you going to have? And think about this. The state of Virginia is going to limit and not allow a man with a valid claim against a valid wrongdoer to go into court and get a valid judgment and then have the punitive valid judgment upheld. But they have no problems with stealing more and more and more of their citizens' money, of the random people's money, of feeding the state more and more, not charging people with the crime to take their money. I got no problem with that. How long do you think until they come and take your money? Till they come and take from you? A month? A year? Tomorrow? Which is why you can either join this conspiracy or pick a number, get in line, wait for it to happen to you. But even with all of this, even with everything going on, there's still a little bit of justice in this world. Amber Heard is getting sued. Insurance company sues Amber Heard to keep from paying for Johnny Depp judgment and legal fees. Here's the complaint for declaratory relief and demand for jury trial. And because I enjoy my man, that umbrella guy, so much and his interpretation of this stuff, at the end of this video, I'm actually gonna let him explain this lawsuit to y'all. But think about that. Amber Heard was insured. She was insured for civil liability in a civil court. So not only is the state of Virginia taking away Johnny's money to the tune of $4.65 million. Not only is the state of Virginia stealing over $300 million in civil asset forfeiture over the past 19 years or whatever, probably gone up since now. Not only does Johnny have an order against him to pay the ACLU, and let's see if he does it. I'm sure we'll keep up with it somewhere. But now the insurance company doesn't want to pay him because Amber lost. Let that sink in. Let that sink in, because in my opinion, the insurance company should have to pay Johnny. The $4.65 million should be reinstated against Amber. And if the insurance company gets a judgment out of Amber, if they take her to court and they get a judgment, then Amber should be on the hook for that judgment. And everybody else should have their rights, and the government should quit impeding on our rights and quit taking our rights away. But that's never going to happen until people quit complaining about it and do something. And I'm tired of complaining about it here on this YouTube channel, so you're probably not going to see me much more. But that's okay. I got something coming that's going to work for all of us. I hope you all stick around to watch it. One world, love, and peace.
Huge breaking AH bombshell. We have just found out that insurers, they have paid out upwards of $5 million and counting for her. That's right. $5 million just for the Virginia case alone. And speaking of the Virginia case and insurers, you have another insurer that does not want to pay out the sum of $1 million liability policy. And what's amazing about this policy is when you start looking at the details of it, you can tell that AH, for everything that she said, she knew that that op-ed was going to get her sued. She knew that there was going to be problems. The thing was, she never thought she would lose. She has now, and yeah, federal court, baby. I mean, it is on. People, they do not want to pay out. Oh, fun times, huh? Fun times indeed. So, hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. And I mean, think about these totals. She said that she had spent in excess of around $6 million for the case. Well, you had $5 million that we know of that was paid out by an insurer. You have another $1 million right here. And well, when you look at the date range on it, the date range is really, really telling. Look at the insurance policy. You have July 18th, 2018 to July 18th, 2019. Guess what popped up right there in the middle? December 2018, you have the op-ed, the one that she lost the Virginia 2022 trial about. It popped up then, so she took this policy out knowing that she was going to get sued. She figured, you know, I'm going to have to pay out money. I can spread that around. Again, $5 million here, $1 million there. Plus, we know the Rocket Man, he was paying money too. Yeah, I mean, that would have covered the bills if she didn't lose. Now, though, that she's lost, you can see this filing here taking her to federal court. These are brand new filings, by the way. And you'll notice this was a policy with a per occurrence limit of liability of $1 million. The policy, it talks about what it was for. It had bodily injury, property damage, personal injury caused by occurrence to which coverage applies. And the policy defines personal injury as injury to other than bodily injury arising out of one or more oral or written publication of material that slanders or libels a person or organization, including other forms of defamation, and oral or written publication of material, including other forms of defamation that violate a person's right to privacy. So you can tell right there, she knew for a fact how this stuff was going to play out. We heard it from her lawyers before, but she denied it repeatedly. But it's right there in black and white, the date range and exactly what it was there for. Then you had the underlying lawsuit. They explain exactly how the lawsuit played out. You understand so much about it too. You know how that works out, what exactly it was over and on. And like they say in this, the problem that they have with paying out isn't that she had a policy. It was the fact that when you look through the statements, when you look at how people answered this with yeses, they were saying that she committed actual malice. That means she was malicious. That means that she willfully did this stuff too, which they say, well, as far as a first cause of action, that is going to violate it. Here you can see it right here. California Insurance Code 533 provides that an insurer is not liable for a loss caused by willful act of the injured, but he is not exonerated by the negligence of the insured or the insured's agent or others. This provision in his implied exclusionary clause, which by statute is read into all insurance policies under California law. The jury's factual finding established that AH's liability was caused by willful acts by her. As a result, as a matter of California public policy and pursuant to that insurance code that we noted, the policy does not provide coverage for her liability as reflected in the judgment order June 24th, 2022. An actual controversy has arisen and now exists between plaintiff on the one hand and AH on the other with regard to the duties and obligation owed between plaintiff and AH under the policy with respect to the judgment order. Plaintiff contends that it has no duty to cover her. Basically, that's what they're saying here because of that judgment. Plaintiff is informed and believes, and on such or information and believe alleges that AH disputes plaintiff's contention and asserts that the policy provides coverage for her no matter what, basically. She could have gone out, she could have done anything that she wants. That's what she's saying. And they're saying, yeah, you know what? You can't. And we're going to take you to court for it. That's what this is, complaint for a declaratory relief. Now, the second cause of action is they're saying, in the California Insurance Code, it provides that an insurer is not liable for a loss caused by willful act of the insured, but he is not exonerated by negligence or insured or the insurance agent or others. So again, you see the same argument. You see it for malice. You see it for willfulness. So when she went out and she did this stuff on purpose, again, she caused this issue herself. She did this knowing what she was doing. She wanted to take down JD. That's what a court decided. And yeah, after a court decided that, they're saying we don't have to cover you. We don't have to do anything at all. This is an amazing document too, because like I said, we know from her own statements that she was complaining about how much this case had cost her. Again, she was saying that she couldn't make payments on her charitable donations because, hey, she was paying out millions. Well, guess what? She wasn't paying out millions. Other people were paying millions. You had insurers paying millions. Again, you had everyone else footing the bill for her except for her herself. So she hasn't really felt any sting from this and on. Again, $5 million from an insurer. You have $6 million coming from the Rocket Man. No wonder there was an insurer that was walking with her the entire time. I mean, this, like I said, they're asking, hey, let us out of this. We don't think we should be part of this at all. We don't think we should have to pay. And you know what? I mean, it's a sound argument. It is one, again, that is bombshell because people, they're saying enough. You lost the case. If she would have won, it would have been different, by the way. They would have not only been paying, but nobody would have ever known about this at all. You would have thought it was JD's fault that she couldn't pay off those charitable donations. But now you know. The entire world knows yet another lie about her. That's right. Not a dime out of pocket until now. But now $8.3 million and counting. I mean, this is going to cost more money as well. Oh man, this stuff is just heating up. But anyway, let me know what you think about this stuff. And as always, I appreciate the heck out of you. You make this stuff work. Thank you. I can't say that enough. Thank you. If you want to help the channel out, by the way, there are links in the description. You being here, though, that is the biggest help of all. So thank you. Appreciate you. End it here. See you soon.